Gosh, we're live. All right, I'm working on it. Give me a second. I am going to go live on Instagram in 5, 4, 3, 2, 1. There we go. All right, hello, everybody. Hello, thank you. Thank you for being here. My name's Otis Landerholm, and I am the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. Thank you so much for being here. All right. Thank you so much for being here. And welcome to another episode of the Empowered Immigrant Live, ladies and gentlemen. All right. Today on the Empowered Immigrant Live, we are talking about the form I-601A. All right. The I-601A, what the heck is the I-601A? The I-601A is a waiver. So we'll get into it. I look forward to talking about waivers with you and how to maximize your chances of winning complex immigration waivers. Okay? So here we are. All right? So here at the Empowered Immigrant Live, we are here to train, to teach, to inspire, and to empower immigrants to make the most out of immigration law and to make the most out of their lives. So today our theme is how to get a marriage-based green card with a waiver, specifically with the I-601A. And my question for you is, hey, do you want a green card this year in 2022? All right, it's now March 3rd of 2022. It's a beautiful Thursday in the Bay, and here we are. And so is this year your year? Because if so, go for it. All right, go for it. Time is ticking. We're already in March. Can you believe it? So if this year is your year, go for it. I'd love to help you with that. And let's do it. All right? And thank you in advance. Thank you for everyone who asked their questions. As always, we got 30 minutes to discuss this topic in English, and then we'll do the same episode in Spanish. Si usted habla español, que venga en 30 minutos. Vamos a hacerlo en español, okay? All right. So, as always, we're talking about the I-601A today, but as always, we got to start with the basics, all right? So, first of all, are you married to a U.S. citizen or to a green card holder? And did you enter the U.S. unlawfully? Because if you entered lawfully, if your last entry was on a visa, you don't need an I-601A. You can adjust status. But if you entered unlawfully, you are accruing unlawful presence, and you will need a waiver. Okay, you will need a quote-unquote waiver to ask forgiveness, ask un perdón, like we say in Spanish, ask for a pardon of the fact that you crossed the border without permission. All right? Hey, we all do things in our lives, don't we? We all do things where they might cause problems. It might not be, sometimes we're not able to do it the full legal visa application process. Sometimes the government denies us the visa application process because it's not easy to get a visa. And sometimes we leave our country freaking fleeing for our lives. And come hell or high water, we're going to cross a border into a new place, into a more safe situation so that we can take care of ourselves and our loved ones. All right? But in doing that, we cause a legal problem. And in doing that, to fix it, we require a waiver. So what's the form I-601A? We call it a provisional hardship waiver. It's a waiver of unlawful presence because remember that if you want to get a green card in the United States, you got to be admissible, okay? But if you entered unlawfully, right? Or if you have certain other problems as well, but today we're talking unlawful presence. If you entered unlawfully, then you will need to request a waiver of that inadmissibility in order to get your green card. even though you're married to a U.S. citizen. Just because you're married to a U.S. citizen, it doesn't automatically make the case easy. We still have to go through the waiver process when you have that unlawful entry. Got it? So if you entered unlawfully, and if that's your only immigration challenge, if that's your only immigration problem, you don't have any crimes, you don't have any fraud, you don't have other issues, all right? And if you're going through the immigration, the green card process, then you should be eligible to file the I-601A, all right? So how do you win this thing? So first of all, you have to have what we call a qualifying relative. So what's a qualifying relative? Basically what that means is it's a spouse or a parent. Kids do not count as qualifying relatives for the I-601A. They can count for other things. But this specific waiver, you need a spouse or a parent who is a U.S. citizen or a green card holder. Okay? So you need a spouse or parent who is a U.S. citizen or a green card holder. You've got to show that that spouse or parent would suffer what they call extreme hardship if your waiver were denied. All right? Extreme hardship if you were to trigger a bar to be ineligible to re-enter the U.S. So how do you show extreme hardship? Not just like a normal amount of hardship, not like a lot of hardship, an extreme amount of hardship. Got it? That's what we've got to show. And so to show that level of hardship, you got to put some work into it. You got to put some work into it. This is like creative, honestly, this is creative lawyering. You want to work with a lawyer who's good, who knows how to like present your situation in a way that's professional and in a way that demonstrates to the immigration official why your qualifying relative, your spouse or your parent, would suffer an extreme amount of harm if your case were denied. Got it? And so we, in our firm, all right, in our firm, we look for 6 different types of hardships that we want to include in your waiver to give you the best chances possible of succeeding. Okay? 6 types of hardships. What are they? All right, I'll go through them briefly. Number 1, we look for medical hardship. If your spouse or if your parent is suffering from some kind of illness or has some kind of diagnosis or has some kind of issue, medical issue, and needs your support, we want to demonstrate it. We want to highlight it. We want to present it carefully in your waiver application because that is a strong showing of hardship. The second type of hardship is emotional or psychological hardship. And in almost every I-601A waiver that my office does, we ask and get and request a psychological evaluation, a full evaluation that shows whether or not there's any emotional attachment or psychological issue and how someone would be affected emotionally, psychologically if their husbands or wives or you know, if they're family members, if the immigrant in their life, if their case were denied. The third type of hardship that our office looks for is either professional or educational related hardship. Like the question is, okay, if this case were denied, would it affect your spouse's, would it affect your parents' career? And how would it affect their career? Would it affect, like if they were to go back to your country with you because the case were denied, that would affect their earning potential. It would affect the goals that they had in place to move up in their organization or their career. Maybe they have a business. Maybe it would completely destroy their business endeavors or their goals related to that. We want to highlight that. The fourth type of hardship that we like to highlight is family, all right? Family unity. If your waiver were denied, if your case were denied, how would it affect your spouses or your parents' enjoyment around the holidays? How would it affect their ability, maybe all of your family is here and none of your family is back home, for example. Maybe, you get together with your family every weekend. Maybe you all go to church together as a family. Maybe you've got children and you read stories together at 7 p.m. every night, all right? Like maybe losing that family unity is a hardship, and we like to document that hardship. Hardship number 5 in my firm, how we have so much success with our I-601As, we show financial hardship. How would separation, how would relocation, if you're separated from your spouse, how is that going to affect you financially? Let's budget it out. How much are you making right now? Right? What does your spouse contribute to that income? If your spouse's income were taken away, how would you be able to account for your expenses? Let's talk about really the financial impact. When an immigration case is denied, it can be enormous. Okay? It can lead to bankruptcy. You get an immigration case denied. Okay? So we want to highlight that. That helps to show extreme hardship. And the 6th type of hardship that my office shows when we're building this type of case is related to your safety or your well-being. All right? And the question there is there some threat? Is there some harm? Is there some violence? Is there some distress, some other problem that's happening or that could incur that you could suffer, that your spouse or your parent could suffer if this case were denied? Like imagine your home country has instability and unrest and violence and persecution happening. And imagine that the only way that you're going to make this work is if your spouse goes back with you to that situation. Well, that is not safe, right? That's not safe. And so we want to document that, and we want to include it in your case. I'm sharing all this with you because I want you to win your waiver, all right? I want you to win your I-601A waiver. The thing that I hate seeing is when a client comes to my office after they hired some other lawyer and their waiver was denied. And now they've come to my office, now spending money again, all right? Now going through the process and the delays and everything else again, just so that we can maximize their chances this time of being thorough and professional and documenting everything and putting everything we can possibly put into it to maximize your chances of getting this thing approved so that you can move forward with the process and get a green card. Okay? That's why I'm saying this. I hope it's helpful. I hope it's useful. The last thing that I'll say is, hey, when you're really preparing a waiver, think outside the box. Put yourself in the mind of the immigration officer who's reviewing it, all right? And you want to document every single type of harm that your loved one, your spouse, your parent would suffer, all right? If your case were denied, you want to document it as much as possible with declarations, with articles, with your tax returns, with your medical records, with your school records, with whatever you have, all right, to show each and every one of these types of hardships. Work with your attorney, work with your paralegals, work with their team. Think outside the box, get creative, then send it off to USCIS. You're going to wait for a long time. These cases take more than a year right now. And once it's approved, then you'll be able to finalize your process of getting you a green card. Okay? My last advice is, and this is true because I see it a lot, don't do this alone. All right? Don't go through the waiver process alone. You want to do it with a pro. You want to win the thing. So you want to maximize your chances of winning, and the way to do that is to do it with a professional who freaking knows what they're doing. That's my 2 cents. That's my 2 cents, everybody. Hope it was useful. Hope it was helpful. Hello to my friends on Instagram. Hello, TikTok. Hello, Facebook. Hello, YouTube. Thank you all so much for being here. Remy. Hello, Fred. Hello. All right. Christopher. Hello. Good to see ya. Javon. I see you there. Hello. Martine. Hello. Juan. Hello. Thank you all so much for being here. I really appreciate it. Let me get into your questions because I do see some questions. And if you're just tuning in, again, my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. You're joining us for an episode of the Empowered Immigrant Live. And now I'm going to start answering questions. If you've got a question, hey, send it over. I'll do my best to answer it. And we're moving along today. We're going to go a little faster than normal today, and we'll make that happen. All right, so my first question today comes from Donna. Donna, hello, and thank you for asking your question. Donna, your question is, my husband did some time in prison, okay? 27 years to be exact. And when he got paroled, he was deported. And we are legally married, and I'm wondering if there's anything we can do to help him come back to the United States. Got it. Donna, wow. Thank you for asking your question. First of all, you are not alone. All right? You are not alone. We have had other clients. There are others that are in your situation. It is not easy. All right? I do not know what exactly that conviction was for, but it's going to be the number one problem, the number one barrier to your husband ever returning to the U.S. is going to be that conviction. And so, Donna, your number one first step is to get all of that conviction record, all of those documents, and let's look through them. Let's look at them, all right? Let's see exactly what code section there was a conviction under. Let's see which inadmissibility grounds that triggers. Let's see whether or not it's a quote-unquote aggravated felony conviction. Let's see whether or not there's any argument that he could be eligible for a waiver of that conviction. Let's see if there's any way that they could reopen or vacate that conviction. Like that, if you could attack the conviction first, in my experience, that is the best way to give your husband any shot at lawfully re-entering the U.S. Okay? So I'm sorry you're in that situation, and I'd love to help you walk through. Often in my firm, when we're looking at cases like this, we work hand in hand with criminal defense attorneys. All right? We handle the immigration side, and criminal defense specialists handle the criminal side, and working as a team, we can make it happen. And yes, we have helped people in your situation, but it is not easy to do. Okay? So Donna, thank you so much for asking that question. I hope my answer was helpful. I wish you the best of luck. If my office can help you at all, please give us a call. We would love to go through that with you. Okay? All right. The next question that I have comes from Amy. So Amy, thank you for asking your question. You say, hi, I am Nicaraguan, and I'm married to an American citizen, and he has a house in the Dominican Republic, and we've been living there for 5 years. We have a 3-year-old boy. He's a U.S. citizen. I want to apply for a tourist visa to visit my mother-in-law, the mother of my husband, because he doesn't want to live in the U.S. at the moment. How's the best way? All right, Amy, thank you very much, all right, for asking that question. You have the right to apply for a tourist visa, and you can do it. You fill out Form DS-160 through the If you go to for example, the State Department's website at the U.S. Consulate in the Dominican Republic, you can, there's a little section for visas, and you can start reading there about where to click to apply and to fill out the Form DS-160 to apply for a tourist visa. You'll need to go in and you'll need to show ties to the Dominican Republic. You'll need to show and explain the purpose of your visit. The main thing about tourist visas is you've got to convince the government officer that you're not coming in to stay. You got to convince the government officer that you are coming in as a tourist. Okay? And so you can do that. And the way I recommend doing that is by showing lots about your ties to the Dominican Republic. All right? Show if you've got a stable job there, if you've got your bank account there, your house there, your son's in school there, your family's there. If you explain all of that when you go into your tourist visa interview, you should be completely fine to get a tourist visa. All right? My philosophy on tourist visas, people apply for tourist visas all day, every day, throughout the whole world. In my opinion, you do not need a lawyer. You don't need a lawyer to get a tourist visa. All right, that is my opinion about it. And if you want help with it, hey, we'd be happy to help you. Sure. It's more expensive to do it with a lawyer, yes. And we can document the heck out of your situation, yes. It's still ultimately up to that same officer. And so sometimes it's frustrating, to be quite honest, to work with an immigration lawyer to apply for a tourist visa, because even with a lawyer, like, there's zero guarantee. It's all up to the discretion of the consular officer. And we do have clients that really want that extra support, right? But Amy, you seem like a smart, sophisticated, intelligent person. You probably can do it on your own. If you do want help with it, we're here. We're here. Feel free to give us a call. All right? Tourist visas. I actually hate them. Should I say that again? I hate tourist visas. Everybody should be allowed to have a tourist visa to just go in and check things out. Like, what's the big deal? And yet thousands, tens of thousands, hundreds of thousands of applications for tourist visas are denied every year for no reason. All right? And they're very frustrating for me. I think it's just the U.S. government kind of just wanting to deny people who are paying and going through the effort to try to do it the right way, to enter and just see the country for a little bit. And thousands more are approved, but still so many of them are denied. They're just very frustrating to me. So I hate tourist visas. I'll say that loud and proud. I think everybody should be eligible for them. And the reality is that the government denies a lot of tourist visas every year. All right, my next question. Javon, thank you for asking your question. You say, hi, does a judge have discretion to grant a green card when someone has criminal records? All right, and specifically you're asking when someone has an aggravated felony. So those are two different situations. Does the judge have discretion? First of all, does the judge have discretion to grant a green card, period? The answer, unfortunately, is no. All right? The judge can't just grant a green card. They can't. They don't have the power or the laws in favor to do that. Immigration judges actually sometimes would love to do that. Grant people a green card. Let's just do it. They can't do that. Okay? And there are some people that could apply for certain benefits. There are waivers that are available for people with certain criminal records. And those waivers and those benefits are not available when there is an aggravated felony. Okay? So aggravated felony convictions are very damaging to an immigration case. That's the bottom line. They're very damaging to an immigration case. They are hard to get around. Javon, the first thing that I would do is, one, let's research and look at that criminal record closely to see, hey, is there any argument that maybe it's not an aggravated felony? Sometimes there are arguments that it's not a quote-unquote aggravated felony as defined by the Immigration Nationality Act. Okay, that's one thing. And another thing is, okay, was there any problem with that conviction? Are there any grounds to reopen the conviction, to plea to a lesser offense instead, to potentially vacate that conviction altogether? Sometimes there are legal grounds to do that. And so anyway, Javon, thank you for asking the question. Don't give up. No, a judge does not have discretion to just grant a green card, period. Criminal records or not. And with an aggravated felony conviction, even less so. It's going to be very difficult to do that. Okay? My next question comes from Martin. All right? And Javon, last thought, if you want help looking at that, give us a call. We'd be happy to look over that with you. My next question comes from Martin or Martin. All right? Martin, hello. You say, hi, lawyer. Is there an exception for a U.S. false claim if you were a minor? Okay, great question, Martin. Martine, nice to see you, all right? And the answer is there can be, yes, all right? When USCIS, or when the United States Immigration Services, even the immigration judge, right, which is not part of USCIS, when any immigration official alleges or is analyzing whether or not a person has a quote-unquote false claim to citizenship, that claim, part of the analysis is that it had to have been willful, had to have been intentional. And when a person is a child at the time that they made it, there is good arguments, there is good case law that says that a child doesn't have the intent, doesn't have the mental capacity to willfully deceive the USCIS official, or depending on, it could have even been false claims to citizenship, could have been for like applying for a job or for any lawful purpose, all right? And so there is an argument that for minors, they lacked the capacity to make the intention to deceive, the intention to defraud, because it's less likely if they're underage that they understood the ramifications of the fraud that they were committing. Okay? So Martin, long story short, yes. The answer is yes. There is an exception for U.S. false claim to citizenship if you were a minor. It's not automatic. It's not just, yay, you were a minor, no problem. You have to show that since you were a minor, you didn't have the capacity to have made the false claim. But yeah, you could certainly make that argument, all right? And my office has made that argument successfully. It can be done. It can be won. You just got to make sure that you're clear with the government about what your position is. Nice. All right. All right. Well, it's 2:35, so I am now out of time. Juan, I see you here. Please join us. Juan, thank you for asking your question. I see it here, and it is in Spanish. Please join us for the Spanish one. I will make sure to answer your question in Spanish. Jose, I see your question. Hello. You say, hello, lawyer. ¿Cuánto demora para sí o no reopen a case? Okay, so we got a cool question with mix of Spanish and English. I love it. Jose, thank you for asking that question. That's a tricky question to answer, though, because it often depends on the judge. If we're filing a motion to reopen a case, it'll depend on the judge. Sometimes it depends on government opposition to our motion as well. Sometimes I would say give it 6 months-ish to receive a decision from the court on average, and it can take even longer. It just can, all right? So right now, everything in the world of immigration is taking forever. Sorry to say it, but it's the truth, all right? Martin, thanks. Hey, you're welcome. Everybody, TikTok, Instagram, YouTube, Facebook, thank you all so much Thank you all so much for joining me. It is always a pleasure to be here with you, and I really appreciate your being here, okay? So that's it, everybody. That's all the time that we have for today. If you've sent a question, if I still haven't answered it, I still will, okay? We will upload the video with the answers to YouTube, all right? And I love your questions because they give me like ideas of what the world needs to hear about, okay? And so if you have a question, please send it. And if this was useful, as always, please subscribe to our channel in YouTube. Click the notifications bell so you can get additional legal updates and news. And if you have an immigration case, please give us a call. We are here to help. We want to help, and we want you to maximize your chances of winning whatever case you are filing for, because I believe, in my office, we believe in immigrants. We believe that immigrants make our country better. We believe that you make our country better. And we want to help you to make sure you just freaking win the thing. All right? Win the benefit, your case, so that you can move forward with your life, continue to contribute to our community and our society and all that good stuff. Okay? That's it, everybody. Thank you so much for joining me. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I will see you next week on another episode of the Empowered Immigrant Live. Thanks a lot. Adios.